Afghan refugees, asylees, parolees who are going through some very challenging times. So we wanted to provide support. So to start off, we're putting on this webinar to give people an overview of what options there are and what they can do. But if you know of anyone in need from Afghanistan, please have them email us at info@cellolaw.com so we can, look at their background and information and try to identify the best options for them, because each immigration case is very different. It's very fact specific. So there's no one size fits all. So today what I'm going to do is to try to give you an overview of the various options and let you know what the terms and conditions of these options are. So let us start. We will start first with the special immigrant visa. Now, special immigrant visa has been used for in a number of different circumstances, but specifically here for individuals that have been previously employed by the US government in Afghanistan or employed with a company that has a contract or subcontract with the US government in Afghanistan. The individual should have worked for the qualifying employer for at least 1 year between October 7th, 2001 and December 31st, 2023. Now that's a reduction from the previously requirement of 2 years. The individual must face threats to safety because of their employment with the US government, or is the surviving spouse or child of a former US government employee who has submitted an application for Chief of Mission approval. And the citation for that is the Afghan Allies Protection Act. The length of service was, like I said, reduced from 2 years to 1 year in July of this year, and allowed for certain surviving spouses and children of US government employees abroad to seek special immigrant status. SIV, special immigrant visa recipients, are eligible for the same resettlement assistance. So it's not just the immigration part, but there's resettlement assistance that is that they are eligible for, and some other benefits, just as refugees admitted, as well as they have the ability to benefit from the Department of State's Reception and Placement Program. It allows recipients, spouses, and children to become permanent residents. There is a path for that, but unfortunately, there are only 50 allotted per year, according to the Department of State. And I'm sure that as someone realizes it, they will increase those numbers. So that's one option. Another option is, you must have heard this often, asylee or refugee. It sounds similar. How are they different? If you are outside the United States, wanting to enter the US because of credible fear of persecution, you would apply for refugee status. If you are in the United States or entering the United States at the port of entry, you would apply for asylee status. So it's location that dictates which one you are. And at each, whether it's abroad or at the port of entry in the United States or with the application, there will be a preliminary credible fear analysis that's done. Do you have the basis to even qualify for either one of these? And for refugees, there are actually 3 levels of refugee status by policy. Number 1 is P1, officially referred to as a U.S. Refugee Assistance Program. That's USRAP. As a refugee for whom resettlement is the best option by the UNHCR, U.S. Embassy, or a qualified NGO. There must be compelling, security reasons in the countries of first asylum. What does that countries of first asylum mean? That's the place in which you are having concerns about your credible fear. And they're in need of legal protection because of endangerment of refoulement, forcible return of refugees or asylum seekers to the country to which they are likely to be subject to persecution. So if you have resettled in Germany, for example, and Germany has taken you in as an asylee, you've got to have, concerns as to why you can't stay in Germany, because you've already been given a safe haven from the country of persecution. The person is in danger of threats of armed attacks where they are located. So if you are in a country that where you think that there is greater access for the Taliban to retaliate, then that would be a basis. You've experienced recent persecution because of political, religious, or human rights activities. And this is usually the basis for most asylee and refugee seekers. So there has to be that's part of the credible fear analysis that they when they say credible fear, if you merely state, I am concerned that, I'm going to be subject to persecution because of my religion or my activities, political activities, or then you have to give some basis as to why. Otherwise, anyone could claim asylum. So they want to make sure that your basis is credible. So, it also helps for women who may be at risk. That's particularly, important given what will happen to the state of most women, with the Taliban rule. For those who are physically or mentally disabled, those who are in need of urgent medical treatment not available in the first asylum country. So persons for whom other durable solutions are not feasible and whose status in the place of asylum does not present a satisfactory long-term solution. Like in the country where you first seek asylum, where you first fled from your country, where you had the fear of being persecuted, is there some political or religious or health-related reasons why you can't stay in that country? Those are the types of things that will be assessed. There's a guide for those who are seeking a referral from UNHCR or the US Embassy, and we will link it to our YouTube video. So please look out for that. Priority 1 referrals, that's P1, must still establish past prosecution or credible fear of persecution from the country in which they had fled. And if they are not a member under P2, which I'll talk about in a second, they will qualify for P1 if they can get a referral from those agencies. So P2 is aimed at granting refugee status to groups who meet certain definitions. 3 categories can qualify for P2 status, P2 refugee status. Afghans who do not meet the minimum time in service for the SIV, Special Immigrant Visa, or, there's only 50 allotted per year, then, you may qualify, but not be eligible on the basis of that. But who have worked or work as employees of contractors, locally employed staff, interpreters, translators for the US government or for International Security Assistance Force or Resolute Support. These individuals are eligible. Afghans who work or worked for US government funded programs or project in Afghanistan supported by a US government grant or cooperative agreement. Afghans who are or were employed in Afghanistan by US-based media organization or a non-governmental organization. The individual must contact the entity that employed them for the referral, who then sends the referral to the US Refugee Assistance Program. And we'll have links to forms and instructions as well. P3 individuals are designated countries, including Afghanistan, with relatives in the US who've already been admitted as refugees or asylees. spouses, minor children, parents of their families in the US, initiated by the relative with status in the US via affidavit of relationship form. Only refugee resettlement programs can complete or submit these forms, and it can be sought simultaneously with the following to join petition via the I-730. So you can file the I-730 and then you can request for this as well. And it has to be within 2 years of the primary individual's admission. And for spouses and children under the age of 21 are those that are eligible. Then you can also, another option is humanitarian parole. You must have heard of humanitarian parole. It is used for a number of different reasons, not just for those in this type of situation, the situation that the Afghan refugees are situated in, but it can be even used for medical reasons, family reunification, sorry, not renunciation, reunification, participation in legal proceedings, protection from targeted harm. So there's a number of ways in which the humanitarian parole can be leveraged. Remember, parole is just giving you, it's not giving you a particular immigration status per se. It's given you the ability to enter the United States in a legal stay. So status is like if you're here as a F1 student, you're here as an asylee, you're here entering the United States pursuant to refugee status. Those are clear statuses, but the humanitarian parole, it paroles you or brings you into the United States in a capacity in which you are legally here, but not in a legal status. So because you're not in a legal status, there's no immediate path to permanent residency for humanitarian parolees. That doesn't mean that they can't change their status to something else that would allow them to seek permanent residence in the US. But that is an additional step that they have to go through because it is not a valid status. And the Operation Allies Welcome Program will allow Afghani nationals who are granted parole up to 2 years. So that gives you plenty of time to seek options. There is an exception, and these individuals fall under the exception for pre-departure COVID-19 tests. They still have to go through medical screening and vaccination requirements after entry. It does require an affidavit of support from sponsors proving ability to provide support for the duration of the parolee stay. Immigration status of the citizen and the citizenship of the sponsor are considered. So they would prefer that the sponsor be either a US citizen or permanent residence because non-immigrants, there's no permanency in terms of being able to say that they can provide support for the full 2 years. And you also must demonstrate why the beneficiary or the person seeking parole cannot obtain a US non-immigrant or immigrant visa or lack of access to relief or protection measures other than parole. Like why parole? Why not something else? Congress authorized parolees through a stopgap funding bill to be eligible for benefits typically given to just refugees, such as Medicaid, direct assistance for food and housing. And instead of allowing them to apply for permanent residency from the from the humanitarian parolee status, they did institute expedited asylum process for those individuals. So the USCIS is required to interview Afghan evacuees no later than 45 days after they file an asylum application. That's the expedite. And the USCIS is supposed to issue a decision within a 150-day timeline. That's a tremendously faster process than is afforded to most. The main issues with these applications is, how do you provide proof? Many people have destroyed their documents in fear of what would happen if the Taliban found the documentation. And if that is the case, there are other types of evidence that you can use. You can use testimony of individuals, and there may be other, maybe not direct evidence, but indirect evidence that can be used. So that is something to keep in mind. There's always the family-based option for most people. Now, unless you are a spouse, unmarried son or daughter under the age of 21, or a parent of a US citizen, you are subject to visa backlogs. Because remember, family-based applications, there's a quota that's set by Congress as to how many can be admitted per year. And it's then further broken down by per country quotas. And so there's often a backlog unless you qualify as an immediate relative. And those are the categories that I outlined a few seconds ago. You know, spouse, unmarried son or daughter under the age of 21, and parents of US citizens. So if you are in that category and you were in the United States, you would file a form I-130 along with a form I-485. The I-130 is what's filed by everyone that wants to sponsor their family member for permanent residency in the United States. It doesn't, the I-130 in and of itself does not confer any status. The I-130 is a form that you submit along with evidence to show that you have the eligibility. That means you're one of the eligible family-based relationships that qualify for a path to permanent residency. You would file that whether you're in the US or whether the foreign national is abroad. Now, if the foreign national is in the US and they have an immediate visa available, and you can find that out if you look at the visa bulletin on the Department of State website. We'll link that here too. And the Department of State website breaks down family categories, employment categories, and diversity lotteries. So the family categories you would have to see, there's F1, F2A, F2B, and it describes what they are. And then they'll have certain countries listed like India, China, and others. And then if you are not in one of those countries that is listed, you fall under all chargeability areas except those listed. So you would have to see what the relationship is and look under that list to see what the backlog is, if any. So the reason why immediate relatives don't fall under that is because they are exempt from the quota. So as I stated earlier, let's go back to the example. If you're an immediate relative if you're sponsoring an immediate relative who is overseas, you file the I-130 in the United States and they process their immigrant visa abroad and then enter the US as an intending immigrant. If your immediate relative is in the United States, as I stated, you file the I-130 and you file an I-485. So the I-485, the I-130, like I said, doesn't matter where you are, you file the I-130, but the I-485 adjusts or changes your status from whatever your current status is in the United States to that of a permanent resident. There are certain terms and conditions after you file the I-485. Can't leave the country, otherwise it'll be deemed an abandonment of status until you get something called advanced parole, which is permission to travel. But I would talk to your attorney. Each person, each situation is different, so it may not be advisable, even if you got permission to travel. So make sure that you speak to your attorney about your particular situation. Now, if you're not an immediate relative, you still may have one of two options. If there is no immediate visa available, you file just the I-130. If there is an immediate visa available and they're outside the United States, they would do the same thing as the immediate relative. because there's an immediate visa available, and you find that out, like I told you, look on the visa bulletin, and they would then process, after the I-130 is approved, their immigrant visa at the consulate abroad. If they are in the United States, then an immediate visa is available. They would file their I-485. Now, if they're in the United States on some other type of visa, let's say you entered on humanitarian parole, where you're legally in the United States, you have even though you don't have a status, you have permission to stay here legally for up to 2 years, and you fall in love with a US citizen. Well, then the US citizen can file a petition for you, and you can adjust because you're an immediate relative of a US citizen. If it is a category where there may be, a wait, you won't be able to file the I-485, but you can still file the I-130. You just have to make sure that you try to stay in some type of status until a immigrant visa is readily available. Now, with all these filings, there are fees associated with it. And for anyone that has done anything in immigration, you can just see how those fees have been increased over the years. I mean, the USCIS is supposed to be a self-funded agency, so I guess you're funding them. So, but there are options. If there's something called a fee waiver that you can file, it's a Form I-912. You file it with your underlying application. Now, if you're the individual that's doing the filing, then they would do what's called a means test. They would assess whether you meet what their requirement is, which is typically 150% of the US poverty guidelines. If you meet 150% of the US poverty guidelines, then whether you're the US citizen or green card holder that's filing for someone, or whether you yourself are applying for a benefit, you can file the Form I-912 with the underlying immigration benefit you're seeking. If the USCIS deems that you have not met the means requirement, they will return the entire petition back. And then what you have to do is refile it with the correct fee. But there are, make sure you look at those options. And as I've outlined, there are a number of different ways. There's the special immigrant visa, humanitarian parole, refugee status, asylee status. There are also issues relating to, have you already, because most of the people have been evacuated out of Afghanistan. There's some people still there, but if you've been evacuated out of Afghanistan, we'd have to look to what the conditions are in the country that you're currently residing and why the United States is a better option for you under those circumstances. So as I stated at the very beginning, it's very fact-based. Each individual has a unique set of facts and circumstances that would identify or would help map out what the best option would be. So if you know of anyone that's in need of assistance, please have them email us at info@cellolaw.com, and we will try to make sure that we connect them we do a preliminary evaluation, and we will assist them with, if we can, with their immigration process. This is something that is incredibly important to us. We have always had a mission of making sure that while we make money, because we are a for-profit entity, from our clients and companies who are getting these great international resources or getting great international family members, that we make sure that we outline a process in which we can help those people really in need. And we do that through our pro bono efforts. And so this is a continuation of that, so that, because we truly believe that if you've got a gift, and I think education is a gift, knowledge is a gift, and you've been blessed with that, you've got to make sure that you are effectuating positive change in the community where you can. And just to let you know, we have various ways you can connect with us. There are social media links that are attached. Please join us either on Facebook, Twitter, listen to some of our YouTube videos that have a lot of useful information that outline and identify options with your immigration journey. Please, subscribe so you'll know when new content has been uploaded. Share with your friends, because the more we can get information, critical information out to individuals, the more that we can empower them to take charge of their immigration journey. And just to let you know, we have weekly webinars every Wednesday at 12 p.m. Eastern Standard Time. Please join us on those webinars. We do a Q&A at the end, and we try to target different types of content every week. So if you haven't, join our webinar, share it with your friends. We'd be happy to hear from you. And now we'll take some questions. Let me pull up to see if anyone has any questions. Please put it in the Q&A. I don't see that there are any questions right now. If you think of something after the seminar is over, please email us at info@cellolaw.com, and we'll be happy to give you some guidance in the best way we can. Like I said, that's something we're very committed to, whether it's today or with our Wednesday webinars, is making sure we provide that service to the community at large. So I don't see any questions. I want to thank you all for joining, and I hope to see you on our Wednesday webinar. This is Lakshmi Chella with the Chella Law Firm. I want to thank my team that helped put this together. I am just the face. I am surrounded by an amazing group of committed professionals that help coordinate all the efforts that you see. Take care. And like I said, any questions, email us. I look forward to hearing from you.